Good afternoon, and welcome to the next edition of our Energy Education Series at Oliva Gibbs. My name is Patrick Schenkel, and the topic today we'll be discussing is The End is Just the Beginning, Post-Closing Considerations in Oil and Gas M&A Transactions. Before we get started, a little background on myself. So I'm a partner here at Oliva Gibbs, and I'm also our Director of Transactions. I'm a licensed attorney in Louisiana, Montana, and Texas, and I generally represent and handle transactional matters at the firm, dealing with aspects of due diligence, title examination, acquisition, divestiture, producing, non-producing assets, drafting, negotiating, interpreting agreements, and generally work in this M&A transactions at the firm. The discussion topics for today. So today we're going to be discussing about 5 core topics. We'll be discussing what is an oil and gas transaction. So if we're going to discuss post-closing of an oil and gas transaction, we first need to go back to what is an oil and gas transaction, what makes them unique, what are the important considerations we need to be understanding of that. Then we're going to be discussing closing. What is closing? What's the definition? What occurs at closing? Next, I'll be going over recording and revenue deck updates. Then we will be discussing records retention. And finally, we'll be discussing final settlement and further assurances. So if you don't know what those terms are, we'll be discussing them, defining them later, and going over the importance of them in oil and gas M&A transactions. So the first topic that we'll be going into is oil and gas transactions. What are oil and gas transactions? What's important about them? What are key insights we need to know in order to know what needs to happen post-closing? So some of the key legal characteristics of oil and gas transactions are conveying real property interests, be that leases, mineral estates. Title review is going to be important. You need to figure out who owns the property. Does the seller own what they're purported to sell? There's also complex revenue allocations in oil and gas M&A. You're getting paid either royalties, overrides, production payments. And oftentimes when you're either buying or selling those royalties or overrides, you may not be in control of the payment of them. You are a third party. Another third party is the one that is paying those royalties to you. There's also regulatory oversight, so state oil and gas commissions, the Bureau of Land Management. There's HSR concerns having to do with antitrust on many of these transactions. And so that's a unique characteristic of oil and gas transactions. Your environmental liabilities, and then finally some operational risk allocation under JOAs. So in order to have an oil and gas transaction, obviously first we need to have a meeting of the mind. The parties need to come together, and one party needs to agree to sell some assets to another party that's looking to buy the assets. So generally the seller is going to own assets that they're looking to sell, obviously for the right price, and the buyer is looking to purchase assets, again, for the right price. There's 2 different characteristics as well within oil and gas transactions. There's marketed deals versus unmarketed deals. So marketed deals are where you're using a third party to help you prepare this deal. You're submitting bids, you're having an auction. You are generally, as a seller, have your materials prepared ahead of time and have kind of all the schedules and exhibits, everything that you need to move forward. You know exactly what you're looking to sell. And as a buyer in those transactions, you generally are reviewing and know there's a data room and there's been a preparation of materials. You generally know what you're looking to purchase. But there's also unmarketed deals. There could be a buyer who's looking to buy something from a seller where the seller has never considered selling it. But if they're asking for the right price, we could have a meeting of the minds, the parties could come together. But I mentioned all of this to say that with an unmarketed deal, there's generally is not a lot of ahead of time preparation of materials for a transaction. And so a lot of what we're going to be talking about post-closing could be slowed down from unmarketed deals. There's also not as much knowledge of the key information needed for those unmarketed deals. And so it's always important to know when you have a deal, whether it's marketed or unmarketed, just the general differences between the two. Another key thing is the agreement on key terms to begin negotiations of a full transactional terms. So this is generally done with a letter of intent, but obviously with that meeting of the minds comes an agreement on generally a purchase price, a general what assets are getting sold, and general time frame, possibly effective date for that transaction. And that all can be put together in a letter of intent or letter agreement, and some sort of non-binding agreement between the parties prior to a purchase and sale agreement or some other type of conveyance. Some general common forms of an oil and gas transaction. So what we mentioned originally, asset purchase and sale agreements, PSAs. That's generally the most common form of an oil and gas transaction. But you could also have a farm out agreement. You could have mineral and royalty conveyances where there's just the conveyance without any purchase and sale agreement that's prepared. And you could also have drill co agreements and production payment. For most of this, the rest of this presentation, we'll be really focusing on purchase and sale agreements and not really too much on the other four concepts. And that's just mainly because we're talking closing, post-closing, and a lot of the key terms that come out of purchase and sale agreements. So what is a purchase and sale agreement? So the PSA generally defines the essential terms and timeline of the transaction, including purchase price, definitions, adjustments to purchase price, defect notice thresholds, deadlines, warranties, indemnity, many other unique provisions. PSAs can range from a couple pages long in length to 50, 100 pages long, depending on how in depth the terms need to be to govern the transaction between the parties. The actual document can also be titled many different things. It could be just titled a purchase and sale agreement, it could be titled a mineral acquisition agreement, a lease acquisition agreement, an asset purchase agreement, or another variation. However, they're all functioning under this same core concept of what we're going to be calling a PSA. One of the key things within PSAs, though, that differentiate ones versus the other is, do you have a sign and close transaction or do you have a delayed closing transaction? And so this is going to be a very important and key concept as we move forward. So a sign and close transaction is a transaction structure where the parties execute the definitive agreement and close the transaction at the same time. So immediately when you sign the PSA, you're also closing the transaction. You're also executing any conveyance instruments and documents needed done. The price is getting paid. Everything is happening at that one set time where you're consummating the transaction. So then the transaction closes immediately or substantially simultaneously. Title transfer, payment, delivery assignments, all occurring at the same time. No interim period between signing and closing. So the key part of this is there's no interim period to do any due diligence, to prepare materials, to look into, do any diligence on the front end. So generally how it works in oil and gas, at closing in a sign and close transaction, the parties typically deliver the executed assignments of the oil and gas leases, wells, related assets, transfer potential operatorship if applicable. If the seller is an operator of any wells, they would transfer the operatorship at the sign and close. Exchange funds, so the purchase price, deliver closing certificates, ancillary documents, and record the assignments, often immediately after closing. When a sign and close is used, a sign and close is common in the situations where you have no third-party consents, so there's no consent to assignments that are required, or consents are not a condition precedent to the closing of the transaction. No regulatory approvals are required, so no state regulatory delay, no antitrust HSR filing is required. Due diligence is complete before signing, so you don't need to utilize the time in a delayed closing for due diligence. And title and environmental review issues have been resolved, or the deal size is modest or low risk. So again, generally sign and close, smaller deals, smaller transactions, not a lot of due diligence, not a lot of risk. You really feel comfortable signing the agreement to consummate the meeting in the minds of the party and closing the transaction at the same time. On the other hand, a delayed closing is where the parties sign the PSA first and close later, so after a satisfaction of conditions precedent. So this structure is generally used when Regulatory approvals are required. So the HSR, we've been using that word a lot. That's the Hart-Scott-Rodino. That's generally going to be required for antitrust, where your transaction is above a certain dollar value threshold, where the federal government needs to get involved and make sure there is no antitrust concerns. It's also this delayed closing is used when third-party consents must be attained. So if you need to attain consent to assignments, those may take a little while. You're dealing with third parties, and so you're generally going to delay the closing from the date the transaction, the PSA is signed, until a later date. Also, a title environmental defect periods must be run. So if you're trying to have title due diligence, trying to claim title defects or any environmental defects, you're going to want to have a delayed closing. So you're going to sign the PSA first, outline in the PSA any appropriate provisions regarding title and environmental defects, and then you're going to close later after potentially those the due diligence has been run. And finally, if financing must be secured, you're going to use a delayed closing. So in those deals, there's always going to be an interim period with covenants governing operations before closing. So some of the key advantages of a sign and close, of a delayed closing transaction are you're having more due diligence done, more investigation of the assets that are getting sold, more time to consummate the transaction, more time to find financing if that must be secured. And so those are some of the advantages. So when is each structure preferable? Use a sign and close when, again, small or mid-size upstream asset deals. We have clean title packages, no regulatory delays, competitive auction requiring speed, or the seller demands execution certainty. So the seller wants to get this done as quick as possible. Use delayed closing when it's a large corporate or basin scale transaction. HSR may be required. Significant title and environmental exposure. Third-party consents are material towards the transaction, and the buyer needs financing runway. Okay, so now that we've gone over a little bit about oil and gas transactions, the next topic we're going to discuss is closing. So we've discussed sign and close, deferred close, but what is closing? So closing in an oil and gas transaction is that point in time when the parties to a transaction consummate the deal. So I mean the transaction becomes legally effective and the ownership of the assets or equity transfers from the seller to buyer in exchange for payment of the purchase price subject to the terms of the agreement. So it's the moment when the contractual obligations to buy and sell are executed and funded. So closing is the legal and financial consummation of the oil and gas deal. So when ownership transfers, money changes hands, liability shifts according to the agreement, and the contractual framework transitions from pre-closing obligations to post-closing indemnity and adjustment mechanisms. So what needs to occur at closing? So there needs to be a transfer of title. So delivery of executed assignments and bill of sale. So this is going to be either the conveyance of the oil and gas leases, wells and wellbores, units and pooled acreage, easements and surface rights, equipments and fixtures, transfer of associated contracts. So all of those things generally that is listed in these conveyances that's set forth as the assets. It's going to need to be conveyed and titles need to be transferred into all of those. So assignments are usually effective as to the agreed effective time. That effective time is going to be set forth generally in the purchase and sale agreement. And that time may actually be prior to the actual closing date for economic purposes. So you may close a transaction on, let's say, March 1st, 2026, but you may make the transaction effective as of January 1st, 2026. And that's okay. That's perfectly normal. And that's just generally done for economic purposes. Generally, a form assignment or mineral and royalty deed is going to be agreed to ahead of time. And that's going to be included as an exhibit to the PSA. And that's going to be the form that's going to be used for the execution and this transfer of title. I will say if a form is not set forth in the PSA, it's going to need to be negotiated prior to closing. And the parties are going to have to reach an agreement in the meeting of the minds on the form that's going to be used between the parties to transfer title. What else needs to occur at closing? Obviously, a payment of the purchase price. The seller is going to want to get paid to transfer the title. So the buyer is going to wire the purchase price as adjusted if any adjustments are necessary under the purchase and sale agreement. Any adjustments would typically include any prorated revenues and expenses, any production imbalances, suspense accounts, any title defect deductions that have been done under the purchase and sale agreement, and any environmental or defect adjustments. So the funds are often exchanged simultaneously with the delivery of the conveyance documents. So obviously the seller wants to make sure they get paid before they transfer the title, and the buyer is going to want to make sure they get the transfer document when they fund and they pay the wire. And so it's often done simultaneously. What else needs to occur at closing? A delivery of the closing documents. So common deliverables for each party. So for the seller, it's going to include the executed assignment that we've gone over, generally an officer's certificate, and evidence of authority, any resignation of operatorship if applicable. So if the seller is an operator, they're going to need to resign as operator. Any required third-party consents, if that's a condition precedent to closing, and any FERPTA certificate. From the buyer, they're going to need an officer certificate, evidence of authority, assumption agreement, and the purchase price payment. What else needs to occur at closing? So transition of operatorship. If the seller is an operator of wells, they'll need to transfer that operatorship to the buyer at closing. And that's going to need to be then the seller is going to need to resign as operator. The buyer is going to be appointed as a successor operator, potentially under a JOA, and any regulatory forms are going to be prepared for state filings. So with that as well, the buyer is going to need to be approved as an operator in the state. They're going to need to have operatorship. They may have to pay a bond, get that all set up prior to closing, prior to that transfer of operatorship. What else needs to occur at closing? Recording and regulatory filings. So post-closing actions include recording the assignment in the county real property records. So as we discussed, oil and gas transactions are generally real property transactions. And so those are going to need to be evidenced in the county records where all of the property is located. Filing change of operator forms with state regulatory agencies. And you're also going to need to update the division orders and revenue decks. So if you're buying any mineral royalty, override and royalty assets, you're going to want to make sure that as the buyer, you're going to get paid on this stuff in the future, and the seller isn't going to continue to receive revenue checks on the assets that they're selling. So with that being said, then, how do we go about recording and transfers? So what needs to be recorded? How do we make sure that any transfers are done so that the buyer can be placed in pay, the seller moved out of pay on any assets that they're getting sold? So first, how do I evidence the transaction? So remember that the PSA is generally going to be confidential and is usually not shared nor filed of record. So the conveyance is the title entered of record evidencing the transaction. Oil and gas leases and related interests, as we mentioned, are real property interest in most producing states. So in order to protect priority, establish record ownership, assignments must be recorded in the appropriate county records. Unlike many asset transactions, oil and gas assets are going to be geographically fragmented. Regulatory oversight is going to be state specific. Title is going to be dependent on public record priority. Revenue distribution depends on accurate ownership records. So recording and regulatory filings are not administrative formalities. They're critical to protecting ownership, operational authority, and the cash flow following these transactions. Okay, so what gets recorded? So typically the recorded documents is going to include the assignment of oil and gas lease, or assignment of wellbore interest, or assignment of overriding royalty interest, any assignments of easements, surface rights, any mineral deeds, royalty deeds. If any real property interests are being conveyed, then there needs to be a recorded transfer and conveyance of those real property interests. You often can record short form assignments to avoid fully disclosing the full contract terms that may be set forth in the PSA. It's also important to know that most PSAs provide that it's the buyers responsible for recording the assignments, and the buyers responsible for any post-closing regulatory filings. Seller cooperation is a covenant, but again, the buyer is going to be responsible to make sure that this transfer gets recorded in any records and the real property records. An identity is going to be tied generally to an effective time. So where do you record it? Each county where the leased or conveyed lands are located. So everywhere that there's real property, anywhere those assets are, you're going to need to record the conveyance document in those counties. This may be in multiple counties, potentially if they're depending on how many assets are getting sold, or even possibly if a lease or conveyed land span multiple county lines, it's being recorded in all of those counties. Also, if you have state leases, you're going to need to make sure to record the transfer or conveyance in the state records. We won't go into this too much as the requirements are going to vary state by state, but it's very important that if you're dealing with state leases and you're conveying a leasehold interest in a state lease, that it's recorded in evidence or approved by those states. Also, if you have federal leases, if we're dealing with leasehold interest in federal leases, you're going to need to record any transfers of operating rights or assignments of record title in the federal records with the Bureau of Land Management. It's important to know that failure to record any of these conveyance can jeopardize priority, create chain of title gaps, complicate any future divestitures by the purchaser, and also impair any reserve lending, borrowing-based recognition. So if you're not credited in the records, you may not be credited as an ownership when it comes to time to trying to look for your reserve-based lending. Again, for state and federal leases, you're going to need to record actually in both state and county records if you're talking about an ownership interest in a state lease. So again, for state and federal, if you have an interest, a leasehold interest in state or federal, you need to record them both in the county and either in the state or federal records, whichever applies. You need to record it 2 places. Also for state and federal leases, it's very important to make sure that the lease number is known and included in the county assignments. So if you're talking about a federal lease and you're looking to put that into your exhibit, it's very important to put the federal lease number in there. So in addition to the lessor, lessee information, any county recording information, also included in that exhibit to your conveyance document, the lease number that may be potentially getting assigned as well. So for federal recordation, the BLM uses their own specific forms. The BLM assignment forms must be filed, and it can be found here at this link. BLM approval is required for non-overriding royalty interest assignments before the assignment becomes fully effective or record, and separate filing fees can apply. With the BLM assignment forms, there's 2 different types of leasehold ownership of BLM leases. There is operating rights and record title. So it's important to know which is getting conveyed and sold to you, because that's going to depend on what form you use and you need to file and seek approval of. It would either be an assignment of record title or a transfer of operating rights. Federal assignments are not effective until they are approved. And federal lease delay, BLM approvals can take months. They're not as quick as recording in the county records. And so you need to keep that in mind, that these need to be done quickly, and it may take the BLM months to get back and fully approve your federal assignment. So I talked about assignments of record title in here. Just wanted to send over just a sample. This is kind of a sample form from the link I sent of an assignment of record title interest. This is the BLM form that you'll need to fill out. And as you can see, this looks much different than any county assignments that you've seen previously or perhaps have put together. But this is the form that you have to fill out. This is the form that needs to be filed for approval with the BLM in order to get their approval and to transfer interest in federal leases, record title. And then this is the form of operating rights. So it's similar to record title 1, but it's slightly different. And this one would be transferring operating rights. And again, these forms are required for federal records. Don't be recording your county assignment in the federal records. It will not get approved. It needs to be on one of these pre-forms that the Bureau of Land Management provides. Okay, so when to record. So when do you need to record these transfers? Recording typically occurs immediately after closing. And again, we said that's generally the obligation of the buyer. So they're going to want to record it same day or within days. Sometimes it can be held in escrow until funding confirmation. So sometimes as a buyer, or sometimes you want to hold that until funding is confirmed, and then we can go record it. It's important to recognize too in what states you're looking to get recorded. So different states have different recording statutes, and so you may be dealing with a race state where if a third party acquires an interest and they have notice doesn't matter. It's a race to the courthouse. The first to record in the records is the record title owner. And other states may be race notice states. And so it's important to know that it's very important to get these recorded as promptly as possible. And if you're in a race notice state or even a race notice state, a delay in recordation could have serious implications and effect on your ownership as a buyer of your assets. So why to record? Why do you need to record? So recording establishes, again, like we've talked about, notice to third parties. So it's putting all third parties on notice. The seller sold these assets. The buyer purchased these assets. The buyer is now the owner. Makes it clear in the record and ownership for everyone, for all third parties that they can see. There's also, as we discussed, priority against subsequent purchasers. So as we did mention, the race notice states, you want to record that as quick as possible and establish that priority. If someone else comes along and says they bought it, but it's recorded afterwards, you want to make sure that you're first in line. Continuative title for future transactions. So if you're purchasing these assets, you may be looking to spin them off and sell them in a future date. You're going to want to make sure that you have record in there for those future transactions and that everything is of record and it's recorded. And then lender reliance. In competitive basins, failure to record can create serious title risks. So again, very important that these are recorded, done as quickly as possible. Obligation is on the buyer. So contract review and revenue deck updates. So let's say now you've recorded your transaction, you've done that, but now you've purchased some mineral royalty interest, overriding royalty interest, and you're looking to, as a buyer, be put in pay. You're looking to get the decks updated from the seller to the buyer. So recording triggers these commercial updates, and generally it's going to be the obligation of the buyer to notify the purchaser of production. So it would be generally the operator, notify the operator of this change in ownership. You're going to need to update the payee information. So you're going to tell them we're going to need to update who owns this asset. And along with that, when you do that, you're going to need to provide the recorded assignments. So you want to tell them, look, we got this recorded. Here's recording information. This is what was transferred. We're now the new owner of this. The seller is no longer the owner. And you're going to want to provide transfer division order records. And so you're going to do all this generally in what's called a letters in lieu. So you're going to want to send this information. This is going to be the most efficient and the best way to notify that operator, notify that purchaser of production that, look, we're selling this interest, or this interest was sold. I'm the new buyer. Please contact me if you have any questions. Please place this in pay. Update your decks as quickly as possible. Until updated, revenues could continue to flow to the seller and be trued up later. We'll discuss that. And later in this presentation, we talked about final settlement statements. But you really, as a buyer, you want to make sure you're getting those funds. You want to make sure that the seller is not continuing payments. You want to do this as quick as possible. Failure to promptly notify could result in suspended funds, misallocated revenue, and potentially extended post-closing reconciliations that may need to occur to true up. And so the other important things with these letters in lieu, which we'll have an example here in a second, I'll show you, is that you're generally, as a buyer, at the whim of the operator on how quickly they do these. You may try to get this recorded, get this sent over to them as quickly as possible, but it's going to be up to the buyer or to the operator and their division order team how quickly the decks get updated. And it's generally going to be when it's filed, when it's done, how quickly they can get it processed. But generally, as a buyer, you want to do all you can to get this done as quick as possible. So here have a letters in lieu, just a general sample, just a template here on what this may look like, what you could send out. As you can see here, it's just advising an operator that production to these wells has been changed from a seller to a buyer. They acquired all these properties by a certain deed that was dated effective, and provide a copy of that to them. And you're just trying to notify the operator that we're really just looking to transfer this ownership and get your decks updated, and you're willing to work with them however possible to get that done. Records retention. So what do you need to do then if you're the seller with all of your records after closing occurs? So there's generally going to be a contractual retention provisions in the PSA. So post-closing access to records is going to be set forth in there. The seller typically is going to transfer their asset-related records to the buyer at closing, and they're generally going to want to retain copies for their own for any tax or litigation purposes in the future. Also, the buyer is often, they're going to grant the seller reasonable access to those records post-closing, potentially for any audit and identity purposes. The buyer and seller are really going to want to work together because you never know what's going to come up in the future with these records. Retention covenants. Some PSAs may require the buyer to preserve transferred records for a defined period of time. They may say that there's no destruction of any records without prior notice. And then they also may provide the opportunity for the seller to copy any records before destruction. So they may allow the seller to make those copies, like we said, for future litigation purposes, audit purposes, any future use that the seller may need of those records that could come up. Okay, so now we're going to go over final settlement and further assurances. So what do we mean by those terms? So a final settlement statement. A final settlement statement is the post-closing accounting reconciliation that determines the final adjusted purchase price between a buyer and a seller in an oil and gas transaction. So it's going to reflect the final calculation of all purchase price adjustments as of the agreed effective time set forth in the PSA, after incorporating and updating any financial and operation data that was not available at closing. So unlike many asset deals, cash flow timing lags production in oil and gas deals. Revenues are distributed generally through third-party purchasers. Joint ownership complicates cost allocation, and production taxes can vary state by state in oil and gas transactions. Further volume-based imbalances have to be valued. That takes time. And so these final settlement statements ensure that the economics match the agreed effective time. So they're really, again, you may have a closing that occurs on March 1st, 2026, but effective time of January 1st, 2026. And so what these final settlement statements are is making sure that we're going back in time to that January 1st, that agreed effective time on when the economic transfer of these assets occurred, and trying to true up between the buyer and the seller all the costs. So to make sure that anything that was prior to January 1st, 2026, the seller is make sure they are getting paid and they have ownership, all of that. And anything after January 1st, 2026, that the buyer is receiving the benefits from that ownership after that date. So it's just a true up, a statement setting forth who's owed what, and then making sure who needs to pay what to make sure that there's a true up that occurs, because information may not have been available at closing that was available later down on the line, where one party received payments that was due to another party after that effective time. So most PSAs generally include a deadline for delivery of a final settlement statement. Could be 90 days post-closing, 120, maybe even 180 days. There's going to be a future end date of when these settlement statements need to be prepared. In addition to that, they're going to include a review period. So they're going to allow a review of 30 days then, once the parties have seen what the other has said they are owing or they may have received an error. Written notice requirement for any disputed items. So if a party puts something on there that they think that they're owed, but it's disputed by the other party, there's going to be written notice where the parties can work through those disputes. And then possibly, if they cannot work through those disputes, an escalation to an independent accounting expert if it remains unresolved. So undisputed amounts, generally what you try to do with these final settlement statements, you want to get those amounts paid promptly between the parties. So where does this all fit in the deal timeline? So a typical upstream oil and gas M&A structure is you're going to have an effective time, which is the economic date when the transfer occurs. That's going to be, again, the date when ownership is technically officially transferred. Then you may have a closing date, and the closing date may occur after that effective date, and that's going to be the date when the funds and the assignments are exchanged. At that closing, you're generally going to have a preliminary settlement statement that's delivered. This is going to be similar to the final settlement statement, but in the preliminary settlement statement, you're just utilizing the information that you have at closing. If you have, let's say, an effective time of a transaction of March 1st, 2026, and then you close on March 3rd, 2026, well, you're not going to have the economic data from February potentially to utilize for that preliminary settlement statement. And so with that preliminary settlement statement, you would then just utilize the information you have at closing. Then you would have the final settlement statement, which would be delivered post-closing. And that final settlement statement, hopefully by that time, be that often could be 60 days or, like I said, up to 188 days later, you're going to have the more information to go back, add in those February payments that may have been made to the buyer or to the seller. You want to make sure that you're truing up those and you have all the information that's needed between the parties and who should be properly getting paid. So again, final settlement statement trues up the estimates that may have been used at closing. We're now at this later date, post-closing, you have more information to actually make a true up. So at closing, again, we've talked about what could lag. So some of the numbers that may just be estimates at closing could be revenue statements, which may lag production by 2 or 3 months. Any joint interest billings, so any JIBs, could potentially be delayed. Any production taxes may not yet be assessed. Any imbalance volumes may not be finalized. And suspense accounts may not be fully reconciled. So again, these final settlement statements replace estimates with actuals, really make sure the parties have a true up, that each party has solid confidence that they're getting what they're owed. What does a final settlement statement typically include? So it's generally going to include revenue adjustments, so production revenues attributable to pre and post effective time. Settlement of any misdirected revenues. So if some revenues were paid after the effective time to the seller that should be technically due to the buyer, you would have a settlement of those misdirected revenue payments. Any potential expense adjustments. So lease operating expenses, capital expenditures, workover cost, overhead charges that are applicable under JOA, and production taxes. You're going to have all these expense adjustments. So making sure, hey, I paid this, but this is technically your responsibility, or vice versa. Any title defect and environmental adjustments. So if those may be unresolved at closing, you may have a title defect that was claimed that the seller is working to cure. And you may say, all right, well, we'll hold this off for the final settlement. You can attempt to cure it. So any adjustments then where maybe they weren't able to cure it and now it is a defect, that's going to lower the purchase price and cause an adjustment to the purchase price that was paid by the buyer at closing, then you're going to want to make those adjustments here in these final settlement statements, set that forth on there. Any imbalances between the parties, or any imbalances, any suspense funds, and any proration true up. So this would be adjustments to account for revenues and expenses allocated between the effective time and the closing date. So the payment mechanism. So after a final agreement, if buyer owes seller, So after these final settlement statements, you put it together, you run all the numbers, you look at who owes who what. If you run the numbers and what the buyer owes the seller is more than what the seller owes the buyer, then the buyer is going to wire the difference. It's the other way around, where the seller owes more and needs to pay the buyer, then the seller is going to wire the difference. So you're really going to look, add the totals between the parties, true this up, see who owes what money, and what the difference may be. You sometimes make escrow funds could be applied in these final settlement statements as well. There may be something that at closing is placed in escrow to wait for this final settlement statement. And it's also important that in the PSA, it may set forth that interest could accrue on any late payments. So essentially, these final settlement statements, these true ups, you want to make sure that they're paid paid properly and on time. And there could be interest payments if either the seller or buyer does not make their payment that's due under these final settlements timely. Okay, so now that we talked about final settlement statements, we've got further assurances. So what is a further assurance? So a further assurance is a provision that is in a PSA. It's a clause where requiring the parties, so typically the seller, sometimes can be both parties, but typically the seller, to execute any additional documents and take additional actions after closing that are reasonably necessary to fully effectuate the transaction and carry out the intent of the agreement. So all this is saying, hey, we made this transaction, we closed, we put together this assignment, we've updated all the records, we've recorded everything, we've done a final settlement, we've trued up, and then later down the line, you're like, we messed something up. We put the wrong effective date in the assignment. We forgot to put something in there. This isn't correct. We need to fix something. That's the purpose of these further assurance clauses, is to really provide between the parties a contractual provision where the seller is now going to assist and make any adjustments and fixes that are necessary to effectuate the transaction, carry out the intent of the agreement between the parties. So in oil and gas deals, further assurances provisions are especially important because asset transfers often involve multi-county real property filings. You may be filing your assignment in 3, 4, 5, 6, 7, 8, 9, 10 plus counties. And there may be problems with some of those recordations, some of those filings. They're going to require regulatory approvals that you may need assistance or help from the seller with after closing. Third-party consents. You may need the seller to still go track down that consent to assignment that's still lingering out there, and they need to go reach out to that third party and make sure we can get these assets properly transferred to the buyer. Revenue deck updates, as we talked about. You may need, as a buyer, you may need the seller's assistance to work with the operator to make sure the deck gets updated. And also federal and state filings. As we mentioned, the BLM is often delayed with their approvals. Maybe they finally come back months later and say, actually, there's X, Y, and Z problem with this. Well, now we're months down the line after closing. And so you'd have to go back and utilize this further assurance clause to seek the seller's assistance to hopefully get those filings corrected and seek the approval that is necessary. So the purpose of these further assurances is the clause functions as a gap filler to address the issues that were inadvertently admitted for closing deliverables that could possibly arise due to clerical errors and recorded instruments required by regulators post-closing, needed to perfect title, operational authority, or discovered during post-closing title review. So any problems that are closed, these are gap fillers to help that. And ensure that transaction is fully implemented, even if additional steps are later required after closing. So what's the typical scope of further assurances? So a standard further assurance provision may require a party to execute corrective assignments. So if there's an error, an issue that needs to be corrected, these are going to require that seller to execute that corrective assignment to, again, carry out, effectuate the transaction between the parties. Maybe require a party to file additional regulatory forms, potentially provide missing consents or ratifications, deliver affidavits of non-production or continuous operation, different things with regards to lease maintenance that may be required of a party, execute division order transfer documents, assist with BLM approval processes, and finally, provide title curative documentation that is necessary. So why is it important in oil and gas? Real property recording errors are common. We've all seen them. And so these further assurances provisions allow you, after maybe months down the line where you notice, oh man, there's an error with our recordation on that document. We need to get it fixed. That's what this further assurance is there for. It's also there to help with federal lease assignments, again, regulatory change of operator filings, and again, third-party consents. So the scope limitation, so these further assurances are often going to be limited to actions that are quote unquote reasonably necessary, or it could be quote unquote consistent with the terms of the agreement, or quote unquote without material additional liability. And so those are all key phrases that may be in the further assurances clause within the PSA. And they're all going to limit the actions that may be required of a party to, again, those three things that may be reasonably necessary, consistent with the terms of the agreement, and without material additional liability. So some of the cost allocation. So obviously, this is post-closing. This is post-final settlement statement. As a seller, you're really like, I don't want to spend additional funds to go do this. And so the cost allocation, so some common formulations are, it may state in there in the provision that each party bears its own cost. It could say possibly that the buyer bears the recording and filing costs that may be necessary for any corrective documents that are needed. And it could potentially even say that the seller is not required to incur material expense at all. So this may be solely on the buyer. However, it is important for the buyer because they're going to make sure that they have good title, that they get everything perfected, they get all their division order transfers done, they get any BLM approval that's required. They're going to make sure that this gets done. And so it's really more of the onus is on the buyer to want to get this done, but really holding the seller's feet to the fire to make sure they do assist and they do help and they do everything that's needed from them to really effectuate the transaction between the parties. But it's also important with these further insurances that there's no expansion of liability on the parties. Really, from a seller perspective, you really want to make sure you're not expanding your liability with regards to these further assurances. So you want to make sure the clause does not create any new representations that may be required of the seller. You really don't want to rep to anything additionally with regards to these. You want to make sure it does not expand any identification obligations. And you're really going to want to make sure it also doesn't alter the risk allocation between the parties. So what's the survival period on these further assurances? So the survival of them, how long they're going to last, and generally they're not going to be open-ended. You really don't want to have this go on 10 years later where a buyer is going back to a seller and saying, hey, I think we screwed something up a couple of years ago. Under this further assurances provision, you're required to do this. Generally not going to be the case. There's going to be a survival period where these are only going to stay, the further insurance clause is only going to survive for a certain period of time. And that time is often going to be tied to survival of representations, or it could survive potentially indefinitely for title perfection purposes. However, it's indefinitely, it's generally going to be just for that title perfection purpose. It's going to be a limited purpose that it may survive indefinitely. So some common post-closing scenarios when further assurances could be invoked. If the county clerk rejects your assignment for format defect, so you can't even get recordation completed on the transaction, well, then you're going to need to go back and get that done. You're going to need to perfect your title. You're going to make sure you get priority, and you're going to need to make sure that the transfer and conveyance is effectuated and recorded. And so you're really going to utilize this further assurance to go back, really get that corrected, correct that formatting defect, get the seller to sign off as needed, get that re-recorded. It can be done to if you omitted a lease in your conveyance or in your assignment, and it's discovered after closing, and it was intended for that lease to be assigned or conveyed in the transaction, you may go back, utilize the further assurance, get it corrected, or get a new assignment of that lease. Operator change form requiring additional signature. So if you need the buyer the seller to sign off on something, you're going to make sure you have this further assurance to really hold their feet to the fire. The BLM is going to require clarification, potentially on an acreage breakdown. You may have additional questions from them that you're going to need the seller to answer. Division order analyst may require additional documentation that you may need as a buyer from the seller. And corrective wellbore assignment may be needed. Maybe you didn't have the right information, something was wrong, you need to get it corrected and fixed. You're going to need to utilize this further assurance provision. So from a buyer's perspective, further assurances are essential for title perfection. They're really just a backstop. If you make an error, we can go back and fix it. They're going to protect against administrative oversights. So anything you may have missed as you're going through these transactions, everything's going fast, trying to get everything done. You got all these timelines and deadlines. Again, it's a backstop, could protect against any administrative oversights. From the seller's perspective, these further assurances, you should not become an open-ended obligation. I mean, you really, as a seller, you don't want to be held as this obligation that exists forever, that they may come back and ask questions of you or get you to sign or fix something. And you really want to make sure you avoid ongoing operational or financial exposure for these further assurances, because that wouldn't make sense. You wouldn't want to sell the assets and still have some operational or financial exposure on the assets that you already sold. So that's further assurances, and that's it for the presentation today. I really appreciate everyone for joining me. Hope you're able to learn something about oil and gas transactions, about what needs to occur after the closing of those transactions. So after the conveyance is done, the purchase price is paid, what occurs, what are the nuts and bolts, what are the major things that need to occur after or may occur afterwards. And I hope you got some good insights into that. As always, get continuing land and legal education credit by scanning the barcode here. You can also sign up for our newsletter, be the first to hear about our upcoming webinars, CLE opportunities. And if you have any questions, please feel free to give me a call, reach out. I love working on this stuff, and I'm happy to answer any questions that you may have or that may arise as you're dealing with the oil and gas M&A transactions. So thank you again for attending, and I hope everyone has a great day.